Hanse, welcome to the Ochapowace Community Tribunal onboarding and training. In today's session, we will be going over the principles of procedural fairness. But before we begin, we will first go over what is a tribunal. An administrative tribunal is a body created by the legislator to carry out delegated functions of government in the public interest. While they are technically part of the executive branch, they often span the constitutional divide by making quasi-judicial decisions to implement state policy. Unlike superior courts, tribunals lack inherent jurisdiction and only possess the powers explicitly or implied granted to them by their enabling statutes. A tribunal's function involves deciding legal rights after hearing evidence, and while they are not courts, they are bound by the duty of procedural fairness to act in a fair and partial manner. So, although administrative justice will not look like judicial justice, tribunals are often the masters of their own procedures, and they are not bound by same strict evidence or procedural rules as a court of law. This flexibility allows them to provide a simplified, streamlined, and cost-effective proceedings that promote broader access to justice rather than traditional litigation. What is the Ochapowace Tribunal? The tribunal was established in 1999. The Ochapowace Community Tribunal was delegated its authority from the Election Act established in 1999, given its authority to monitor, conduct, govern the election period for the Ochapowace First Nation. The Community Tribunal is authorized by the Ochapowace as expressed by this act and other laws of the nation. The Community Tribunal is hereby mandated to manage and make decisions on the following matters: election appeals, develop and monitor the standards of conduct during the campaign period, grievances, discipline, or removal from office as contained in the Community Tribunal Manual. Given the authority, it is the tribunal's responsibility to ensure that their decision makers possess the capability to make choices fairly, promptly, and without bias. Next, we will be going into procedural fairness. Procedural fairness is a fundamental legal principle in administration decision making. It ensures that processes are conducted justly and impartially. This concept establishes a framework for how decisions should be made, focusing on fairness of the process rather than the ultimate result. So, because this is a fundamental principle, not prisoner, procedural fairness is a fundamental principle that serves as a core component of the rule of law. For executive and administrative decision making, it ensures that justice should not only be done, but should be manifestly and undoubtedly be seen to be done. This principle requires public authorities to act fairly when they make administrative decisions other than those of purely legislative nature that affect the rights, privileges, or interests of an individual. Administrative bodies need not generally to comply with strict rules of evidence. However, they generally are required to be procedurally fair. So there are key elements of procedural fairness: the right to notice, disclosure, the right to be heard, the duty to give reasons, and an unbiased decision maker. We will go into depth in the following slides of each of these principles. The right to notice. Individuals must receive adequate notice of any proceedings or decisions that can affect their rights or interests. This notice should clearly inform them of allegations, the relevant information, and the specific issues to be addressed. Providing sufficient time to understand the case and prepare a response is an integral part of this requirement. The right to notice is a fundamental component of procedural fairness. To satisfy this duty, adequate notice must go beyond mere alert that a decision is pending. The affected party must know the case made against them. This requirement entails being informed of the substance of the allegations, the specific information or evidence being relied upon by the decision maker, and the potential consequence at stake. Such disclosure is essential to ensure that individuals have meaningful opportunity to respond and allow them to correct or contradict the information before the final determination is reached. Disclosure. Disclosure means that parties exchange important evidence that they want to give to the decision maker to make their decision. Each party needs to know what information the other party is relying on so that they can make an informed arguments about all evidence. Administrative bodies with oral hearings are likely to have disclosure rules in their own rules of procedure. If a party fails to disclose relevant evidence to the other side that they are relying on, and the decision maker proceeds with hearings without giving the other side a chance to review the documents or request an adjournment, that can be seen as procedurally unfair. Being heard effectively requires knowing what information the decision maker is relying on. Procedural fairness often dictates robust disclosure of evidence or summary of information so that you have meaningful opportunity to respond to the case against you. To align with the principles of procedural fairness, it is important and crucial that all evidence being used to make this decision is disclosed to each of the parties. Next is the right to be heard. A meaningful opportunity to prevent one side of the story is cornerstone of procedural fairness. This includes the chance to provide evidence, make arguments, and respond to any allegation or information presented against them. This right ensures that all relevant perspectives are considered before a decision is finalized. Right to be heard can be an oral hearing or a letter of submission. Depending on the factors above, the hearing may take several forms. Written submissions. This is the most common form of hearing in administrative states. Individuals are permitted to provide written documentations, letters, or evidence through the and to be considered by a decision maker. Oral hearings. An in-person or oral hearing is not always mandatory, but it is required in specific circumstances. If credibility is an issue, an oral hearing is mandatory when a decision turns on credibility, where a decision maker must choose between competing versions of the truth. High stakes. Trial-like oral hearings are often required when the consequences are severe, such as suspension from a profession or a academic institution. So it is important when you sit on the tribunal, you must understand that each person that has an allegation or a case against them, they have the right to hear, and the right to be heard can look like different ways, but it is based on the circumstance, and you, the tribunal and decision makers, will determine that circumstance. Next is the duty to give reason. The duty to give reasons is fundamental in of modern Canadian administration law, serving as the primary mechanism for ensuring that public decisions are justified, transparent, and intelligible. While the traditional common law position was that administrative decision makers were not required to provide reason unless mandated by statute, the law has evolved to recognize reasons as a requirement of procedural fairness in many contexts. So this just indicates that the duty to give reason essentially was not a principle of procedural fairness, but given the law has evolved, it has now become a requirement. And the hallmarks of reasonableness is to be sufficient reasons must demonstrate justifications, transparency, and intelligibility. Tribunals do have more flexibility than courts. As long as the tribunal can show an explanation for their decisions was reached, that it was coherent, logical, and accounts for all relevant facts, context, and applicable laws, regulations, and policy, it could be seen as operating to align with the principles of procedural fairness. Next, the next procedural fairness principle is an unbiased decision maker. The individual or body responsible for making decision must be impartial and free from any actual or perceived bias. This means a decision maker should not have a personal interest in the outcome or have prejudged the matter. The appearance of impartiality is as important as actual impartiality to maintain public confidence in the decision-making process. Parties have a right to a decision maker that acts in a neutral and unbiased manner, free from influence that could lead to a reasonable person to doubt their impartiality. The duty to act fairly cannot exist if a decision maker is biased. An impartial decision maker is required to approach every case with an open mind, free from actual or perceived prejudice, because it is impossible to determine a person's precise internal state of mind. The law treats an unbiased appearance as an essential standalone component of procedural fairness. So your job on the tribunal is to ensure that you are treating every individual case with an open mind. And this process is not only important for the parties involved, but also to build a good relationship with the public and to build trust that we are coming to decisions with good intentions and unbiases. So other than that, this is all this we have completed the training for procedural fairness, and I wish you luck on your future endeavors and congratulations on being selected as a tribunal member. There is a lot of responsibility, but I'm sure to whoever's listening that you will do a good job and you will lead with a good heart. So thank you.